Judgment in the appeal, the Queen on the application of Newhaven Port and Properties Limited and East Sussex County Council and another.
Lord Hodge will give the judgment to the court.
In 1883, the Newhaven Harbour Company built a breakwater which extends 700 metres out to sea. The forces of nature, and particular wind and tide, rapidly created a beach within the breakwater. It is now known as the West Beach. It is bounded on the landward side by a high sea wall and to the west by the breakwater. There are steps down from both the sea wall and the breakwater to the beach, which appears and disappears with the tide, being wholly covered by sea for 42% of the tidal cycle. West Beach is, in short, a tidal beach or foreshore created by nature as a result of the construction of the breakwater. Local people have long enjoyed the beach as a place where they could engage in seaside activities when the tide was out. The Harbour Authority shut off the beach during both World Wars, but otherwise did not prevent the public from using it. In 2006, Newhaven Port and Properties Limited, which is now the Port Authority, fenced off the steps to the beach from the sea wall. The steps from the breakwater had been fenced off at an earlier date. The people who enjoyed the beach wanted to have it registered as a town or village green under the Commons Act 2006. That act allows local people to apply to register land as a green if a significant number of local people have, for 20 years previously, engaged in lawful sports and pastimes on the land as of right, that is, without the permission of the landowner. On 18th December 2008, Newhaven Town Council applied to the Registration Authority to register the land as a town or village green. The Port Authority objected, and in 2010, a public inquiry was held. The reporter, Ms. Stockley, found that the statutory tests had been met and recommended that the beach be registered as a green. On 22nd December 2010, the Registration Authority resolved to accept the application to register the land, but because the Harbour Authority had challenged the decision, the beach has not been registered pending the outcome of this appeal. Mr. Justice Ousley, in a judgment dated 2nd May 2012, quashed the decision of the Registration Authority on the ground that the registration of the beach as a green was incompatible with the functions that Parliament required the Port Authority to perform in operating, maintaining and improving the harbour. He found that the Port Authority's plans to extend the harbour in exercise of their statutory powers could conflict with the public's exercise of recreational rights if the beach were to be registered as a green. The Town Council appealed to the Court of Appeal, which, in a majority judgment, reversed his decision in a judgment dated 27th March 2013. The Port Authority then appealed to this court, and it advanced three principal arguments. First, it argued that because the beach was part of the foreshore of this country, there was a presumption that the public used it with the permission of the Crown, or in this case, the Crown's successors as owners of the foreshore. If, therefore, the public used the beach with the permission of the Port Authority, they had not asserted a right against the Port Authority to use it as of right. Secondly, the Port Authority argued that their bylaws on a proper interpretation implicitly gave the public permission to use the beach so long as that use was not inconsistent with the operations of the harbour. Again, that permission, which was revocable, prevented the public asserting a right against the Port Authority. The Court of Appeal had agreed that the bylaws had that meaning, but the Port Authority argued that that court had been wrong to hold that the bylaws could not establish that the public had used the beach with permission because they had not been communicated to the public during the 20-year period of user on which the Town Council founded in its application for registration. Thirdly, the Port Authority argued that because the public's use of the West Beach, if protected by registration as a green, might be in conflict with the Port Authority's exercise of its statutory powers to operate and improve Newhaven Harbour, that incompatibility barred registration of the beach as a town or village green. In a judgment which Lord Newberger and I prepared and with which Lady Hale and Lord Sumption agreed, this court allows the appeal. Lord Carnworth has produced a separate judgment agreeing that the appeal be allowed. In relation to the first argument, the court has decided that it is not appropriate in this appeal to determine the extent, if any, of the rights of the public at common law to use the foreshore beyond the established rights of access for navigation and fishing. It is an important question which can be addressed in another case. It is not necessary to reach a decision on that issue because in this case the court has reached a clear view on the other two arguments. The court is persuaded by the second argument and holds that the bylaws impliedly gave permission to the public to use the beach and that the public law right which the bylaws created meant that the public used the beach with the permission of the Port Authority, whether or not the bylaws were brought to the public's attention. The court also accepts the third submission. The registration of the beach as a town or village green would make it a criminal offence to interrupt its use by the public for recreation and would be incompatible with the use of the harbour as a working port, which is what Parliament has required the Port Authority to facilitate. Lord Carnworth sets out in his judgment further materials on the nature of the rights of the public to use the foreshore, which are relevant to the first argument. He also states that he would have preferred to decide the appeal only on the second argument. The court unanimously allows the appeal.